Good morning, Senate Judiciary, taking up S-259 again, the Climate Resiliency Bill, and climate change cost recovery issues. Rick Heat from the Climate Accountability Institute is joining us from somewhere. Looks like we've got mountains and snow behind us. But Rick, welcome to Senate Judiciary. I'm from Bennington County, Dick Sears, the chair. We have
Nader Hashim representing Windham County.
Bob Norris, Franklin County, and the town of Elberg in Grandel County.
Tanya Bihovsky, Chittenden Central.
And Senator Baruch is not here. He's in a conference today, and he's the president pro tem of the Senate. Evidently, pro tems are meeting somewhere. So please go ahead with any testimony you have. We're delighted to have you with us.
Good morning. Thanks so much, Chairman. Appreciate the invitation to testify this morning on this important bill. On a personal note, I want to say that I've been deeply concerned about climate change and climate impacts for many decades. I've worked in the field for 40 years. I founded the Climate Accountability Institute in 2011 in order to do the scientific work necessary to attribute source emissions to fossil fuel and cement companies as a way to as a pathway to holding them accountable for climate damages. And I heartily support the cost recovery bill that you are discussing. I know that Vermont's climate impacts and costs will only rise, and I look forward to the assessment by the Treasury Department of Vermont to estimate the total cost to be recovered from fossil fuel companies. And I certainly agree that those costs and impacts should not be borne simply by the citizens, taxpayers, and businesses, and the Vermont's Treasury in order to deal with the impacts of climate change. What I will be testifying about today is a way to quantify emissions sourced back to fossil fuel and cement producers as a way of allocating whatever cost recovery is deemed necessary by the state of Vermont and attributed to the fossil fuel companies. So let me share some slides.
Give me 1 second, and I will let you know when you're all good to share. And you should be all set to just hit share screen and do that.
Do we have a copy of this?
Yeah. Your folder underneath the other one.
Great. Thank you. Go ahead. I think we're set.
Okay, so how do we account for emissions traceable back to the fossil fuel companies? The Carbon Majors database that the Climate Accountability Institute and I have created over the last 20 years seeks information on why companies and how much they have produced. And why we do this is that the companies themselves have produced the lion's share of the carbon fuels that cause climate change. The companies have been aware of the threat of climate change to their business since the mid-60s. They have misled consumers, investors, and legislators on climate risk. And they have the technical skills, capital, and moral responsibility to reduce net carbon production in line with science-based target of 1.5 degrees centigrade. And I might add, they have the moral responsibility to help mitigate the costs of the impacts of their products. I won't read this whole slide, but I just want to describe the process that we go through in quantifying emissions. We first set a threshold to focus on mid-sized and large corporations in the fossil fuel sector, equal to about 8 million metric tons of carbon in a recent year. We there have 105 carbon major entities, most of which are investor-owned corporations, several state-owned enterprises, and some government-run coal ministries in former Soviet Union, China, Kazakhstan, etc. and some 40 coal producers and some 70 petroleum and natural gas producers are in the database. We take an historical perspective, and we have acquired data on production back to as early as 1854 for a couple of coal companies. And we look at annual reports and Form 10Ks submitted to the Securities and Exchange Commission required by law in order to quantify and enter in our worksheets how much of each carbon fuel, namely coal, crude oil, and natural gas, on an annual basis. We have sought annual reports from dozens of libraries around the world because these companies are situated not only in the United States, but globally. We enter production data in the worksheets. We account for mergers and acquisitions, all attributed to the extant oil and gas and coal company. Importantly, we deduct for non-energy uses of carbon products in order to quantify emissions that end up in the atmosphere rather than being sequestered in petrochemicals and road oil and lubricants and other materials that don't go into the atmosphere. We apply robust and peer-reviewed emissions factors, and we cover both direct Scope 1 operational emissions and indirect product-related emissions from the fossil fuels that each company makes available to global commerce. Here's a single company, Equinor in Norway, and their history of oil and gas production. This is illustrative for you only, but you can perhaps read some of the details in your printed sheet. A larger company and a much more complex one is Chevron, since it has merged with and acquired a number of other companies over its history. Texaco and 76 and Getty Oil, for example, and Gulf Oil over its history. So a very complicated and fully documented worksheet on how much oil, gas, and in some years coal each company produced and made available to global commerce. We then multiply that by emissions factors to reach to estimate its emissions of carbon dioxide and methane, both for operational and product-related emissions. So for product-related emissions, we deduct for net non-energy uses of petroleum, as I mentioned earlier. We account for natural gas liquids with lower emissions factor, and we account for natural gas and coal production. On the operational emission side, which are about 12% of each company's total on average, includes sources such as CO2 from flaring, CO2 from gas processing, CO2 from substantial use of its own fuel in refineries, equipment, pipelines, and field operations, and substantial methane from natural gas and oil production and pipelines, etc. Again, for illustrative purposes, this is the final worksheet for emissions attributable to 75 crude oil production companies from about the 1940s to 2022. And that has resulted in the production of 1.3 trillion barrels of oil has resulted in the emissions globally by end users using these products as intended, namely for combustion, of nearly 500 billion tons of carbon dioxide over their history. In aggregates, all 105 entities in the Carbon Majors database reach 70% of all fossil fuel and cement emissions since 1751. The black line are global emissions from fossil fuels and cement, and the red line are emissions attributable to the 105 entities in our database. Since the Carbon Major methodology focuses on emissions traceable to net equity production of fossil fuels, are traced in red and black lines. There are two other major ways of attributing emissions to oil and gas and coal companies, and that is by estimating emissions from each company's refinery output. That's the green line in both of these charts. The left is Chevron over the history from 1950 to 2022. And the third method is emissions based on petroleum product sales, which are typically much larger than each company's production of crude oil. That's the ochre line. And you can see that in Chevron's case on the left, the ochre line is barely above what its production is. But for Shell on the right, sale of petroleum products is much larger than its produced fossil fuels. Senate Bill 259 is based on petroleum product sales times EPA's emissions factors, which is a reasonable approach. But I would suggest that equitably sharing source emissions for non-energy fossil fuel emissions leads to a more fair distribution of damages and cost recovery estimates. And what I mean by that is that there are non-energy emissions that are part of the global anthropogenic or human-caused emissions, such as methane from animal husbandry, non-energy methane from landfills, carbon dioxide from deforestation, for example, and loss of soil carbon, and other sources such as nitrous oxide that should be taken into account in the final attribution of payments to fossil fuel companies. Now, in terms of when to set the boundaries for starting the clock on responsibility and cost recovery, the current legislation is focused on the period from 2000 to 2019. That's perfectly reasonable, but I want to tell you that the carbon majors database goes back to as early as 1854 and has a number of company data going back to 1900 and 1950. And there are rational reasons for setting the clock in a different date. For example, the first UN Conference on the Parties was in 1995. The UN Framework Convention on Climate Change was adopted in 1992, in which common but differentiated responsibilities were assigned to states. And as you will note, my work is focused on common but differentiated responsibilities attributed to fossil fuel companies as an alternative pathway to responsibility. The Intergovernmental Panel on Climate Change was formed in 1988, same year as Jim Hansen's testimony to the Senate, US Senate in June 1988. And for decades now, we've had incontrovertible evidence of human-caused climate change. And in my mind, and with demonstrated support by other experts in the field, fossil fuel companies knew of or have willfully ignored evidence of dangerous interference with global climate since at least the 1950s and 1960s. In my view, oil companies should have been aware of the potential harm, not only to their business model, but to the world at large from the production of future fossil fuels. And data in the carbon majors database are publicly available from 1950s to 2022, and we will add 2023 data will be public later this year. I want to focus just for a moment on the period of time that the cost recovery bill looks at for cost recovery. And in my database, 68 companies meet the 1 gigaton CO2 threshold in the legislative language. And I wanted to note that on the February 8th meeting, one of you senators raised the question of how large is 1 gigaton of CO2. And I ran a back of the envelope calculation suggesting that this is a large number indeed, as we will discuss in a moment, but it's equivalent to a car at 25 miles per gallon driving, if it were possible, from Earth to the sun 30,000 times. That would emit 1 gigaton of carbon dioxide. A more earthly metric would be the same 25 mile per gallon car would have to drive around the circumference of the Earth 113 million times around the Earth. So a substantial amount of fuel. And I have put an illustration of the 5 largest investor-owned companies since 1980 to 2022 on the left view of your screen. The top companies are ExxonMobil, Royal Dutch Shell, BP, Chevron, and Peabody in that order. On the right, you see the quantification attributed to the largest 12 companies led by Saudi Aramco, and the 12th company being Chevron at thousands of million tons of carbon dioxide. So we're talking about gigatons, and the largest case, Saudi Aramco, 33 gigatons over those periods of years, and Chevron 9 gigatons over the same period of time. And in terms of proportion of global emissions, Saudi Aramco is nearly 5%, whereas Chevron comes in at 1.3%. I just wanted to post some of the peer-reviewed publications that I've participated in, either as a co-author or lead author, on verifying these emissions and attribution and methodology in peer-reviewed publications. I'm happy to take your questions.
Other questions? Senator Norris to start.
Sahid, thanks for being here. I appreciate it. I am not here to discuss the global warming, whether it's yes or no or whatever else, but this is what I am looking for. On page 1, we say the fossil fuel producers are aware of the threat of the carbon emissions to their businesses since the mid-1960s, and then again on page 5, you say fossil fuel companies knew of or willfully ignored evidence of. That's what I'm looking for. I need to see that evidence, that not anybody's personal opinion, that they knew about this. There's something in writing. Just where can I find this, sir?
It is my view, and I can send some peer-reviewed papers in your direction, that leading scientists were making public statements with participants from the oil and gas industry and the American Petroleum Institute. For example, Edward Teller testified to the American Chemistry Council and the American Physical Institute, with fossil fuel personnel in the audience, suggesting that future emissions of fossil fuels and carbon emissions would lead to very dramatic climate impacts. That was,
and I appreciate that. And I'm not here to, your view may be right. I totally agree with that. I'm not here to question your view on this. I just need to see something that they had, some evidence that they had knowledge of this. They admitted to this, something. That's what I'm looking for.
I can't provide you any evidence that they admitted to this. They would not publicly admit to that, to my knowledge, since they wanted to later on discount the reality of climate change science and disinform the public. I understand your question. I will provide some scientific literature on what was in the public record from as early as the 1950s. But we're looking, in terms of accountability, more towards 1988 or 1980, where the formation of the IPCC and National Academy studies in the late 70s made it very evident that fossil fuels and carbon emissions were primarily responsible for climate change.
And I believe in the bill, the way it's structured, that's what governs, is that they knew or should have known, and whether they admitted it or didn't admit it, it's strict liability. And science is certainly providing us with information that it is part of the cause, at least of this.
And I don't dispute that. I just want something.
Okay, I
that shows
understand, but that's
I've
what
seen the
strict
bill.
liability is, and that's what the Superfund was, or is. And this is based upon someone on the Superfund law. Other questions? I actually have a question about the companies themselves. I don't see Venezuela on this list, and I thought that they were one of the major producers with Citgo and the other company that they can't think of the name of it offhand, Valero.
Yeah, Valero is not on the list because my methodology focuses on companies that extract fossil fuels, oil, gas, and coal, and Valero is a refiner and a distributor. But But Petroleos de Venezuela certainly is on the list. It's just a little bit lower down than the top 12 that I showed. I did mention that 68 companies
Yeah,
meet the requirement and exceed the 1 gigaton emissions over that period of time.
of course, our chances of getting any money out of PetroChina is probably pretty low.
Yeah, and I should mention that this list is not post review of which companies have business interests in or
States, right.
just my list.
Or in Vermont, yeah, it'd be hard, I don't know that we have any relationship in Vermont with PetroChina. Anyway, Senator Machine.
Thank you for your
I haven't
testimony.
gone to one of their gas stations recently.
Thank you. My question for you, this is really science dense, I think. And I'm still there, there's, the nuances of it. I'm still I want to do a deeper dive into that. But my question, I really want to make sure that whatever formulas we end up using are accurate and rational and make sense. And so, and in looking at the bill, I see that it's to measure between 2000 and 2019. Is it possible to measure up to 2022, 2023? Because I'm looking at, the numbers that you list here, like on page 2 and 3, for example, with, what Chevron has produced between 1912 and 2022. And so basically, I guess my question is, can we develop an accurate and rational formula that measures that creates an accurate measurement between 2000 and 2019 or 2022 or 2023?
Yes, I believe we can. I do have data in my database all the way up through 2022. Companies are just filing their SEC 10Ks this month and next month. So later in the year, we'll be able to supply data through 2023 from 2000 or whichever year you want to start.
Thank you.
And I should reiterate that I would think it would be rational and equitable to also account for non-energy emissions of greenhouse gases. Since this is a global issue, there are other sources of human-caused emissions that should be accounted for in this metric. And by my way of looking at it in the data, I have looked at fossil fuel sector CO2 emissions plus methane attributable to energy production is almost 70% of the total human-caused climate emissions. The other 30% is from animal husbandry, from non-energy methane, nitrous oxide, and other greenhouse gas sources, deforestation, for example.
Thank you.
Thank you.
Thanks.
Other questions? Thank you so much for joining us this morning. We really appreciate it.
Thank you so much, Chairman and Senators. Thank you so much.
Thank you.
Well, our next witness is Jeff Hand, attorney with Sanders. I'm just gonna stumble over that one.
Rob Vogel.
Thank you. And Hand.
Good morning.
Good morning.
How are you all this morning?
Good.
Good. Thank you for your work on this important bill. My name is Jeff Hand. As the chairman just mentioned, I'm an attorney at SRH Law in Burlington. I'm here today testifying in a pro bono capacity. I've consulted with VPIRG on some general legal questions related to the draft legislation, most of which you've already heard from other witnesses about in detail in your prior sessions. I'm here to follow up on some questions that may have come up in that testimony, but really just to be available as a practitioner with experience in this area as a resource to the committee. Before I turn to questions, there's a little more background on my experience. I've practiced law here in Vermont for about 20 years. I've focused primarily on environmental and energy-related work. I represent businesses, nonprofits, individuals, and municipalities in a wide range of cases in state and federal courts. And I've been involved in a number of climate-related cases as well. In the early 2000s, I represented a number of municipalities around the US in a case suing the federal government to require consideration of climate change impacts related to funding decisions the federal government was making on significant fossil fuel projects. That case was based in part on the significant costs and impacts that those communities and their residents would experience from climate change. It was one of the first cases to find that municipalities had the right to sue the federal government over the impacts related to climate change. But to be very clear, those cases were really just about consideration of climate change impacts. They had nothing to do with addressing how to mitigate or pay for those well-known impacts. Mr. Heedy was actually my witness in that case almost 20 years ago. And at the time was groundbreaking in his accounting methodologies. And I think as you just heard from him and from Professor Mencken, we've really seen even since then dramatic advancements in how to do this individual accounting on climate emissions. But one thing that has not advanced in that 20 years, or hasn't advanced at the pace that's really required for this emergency, are the legal tools we need to help communities, states, businesses, and individuals who are directly impacted by the crisis. As a practitioner in this area, it's really been heartbreaking to see how little progress we've made there, particularly at the federal level. And I say heartbreaking because the impacts that these experts have been predicting for decades are now upon us. As you just heard from Andy, businesses and communities here in Vermont are experiencing the impacts directly. We saw that in July in the floods, and we will see more of that. And as Professor Mencken just mentioned, it's often the most vulnerable amongst us that bear the greatest cost. I know there will be many hours spent in this building this year thinking about how we help Vermonters who are experiencing these impacts, and how we even partially mitigate the financial costs they've suffered. And the question to me is, when we as a community talk to Andy or to a homeowner in Barrie or a business owner in Montpelier and say, sorry, we don't have the money to cover your costs. When we say to taxpayers generally, we need to cover more costs, will we also be able to say that we're doing everything in our power as a state to ensure that those who contributed to the causes are paying their fair share of those costs? And that's what S259 is about. It's a critical part of addressing this balance of benefits and burdens associated with the production and sale of these products and their resulting impacts. And we're talking here about making some of the very real externalities of using these products internal, bringing the cost back in, so we're taking those into account and fairly apportioning them. We're dealing with a really significant crisis here. I think that's been acknowledged. It has long been predicted and the cause is well established, and it's only going to get messier and more expensive for Vermonters. As the chair has noted, this is really about that well-established legal principle that the polluter pays. Mechanisms that have been long established in state and federal law. To me, this goes back to even a more basic preschool principle, one we learn, probably one of the first lessons we learn as kids. If you make the mess, you help clean it up. And we're going to be dealing with a lot more of a mess here in Vermont and certainly around the world. But we should have mechanisms that allow Vermonters to recover from those who contributed this cost, a portion of the costs. It's not punitive. It's just about using the legislative authority of the state to make rational decisions about who should cover those costs. I know there have been some questions about whether the state can be challenged for this program. I've listened to prior testimony and I agree with what you've heard there. There's no guarantee how a court would rule, but the state has very good arguments that this approach is constitutionally appropriate and defensible. I'm happy to answer questions about that. I don't want to repeat testimony, but I do want to touch on just a couple of procedural issues. So one of the questions that I heard in prior testimony and questions from the committee was about what litigation might look like if the state is sued over this. And I think it's important to be clear about what might occur. It's unlikely that that's going to be extensive litigation. It's very likely the state will be challenged. And that will likely be a facial challenge to the statute that occurs in federal court. It would likely be based on constitutional grounds. And because it raises federal questions, it'll be appropriately raised in federal court. Some of the cases you've heard about where there have been disputes about whether a case should be in state court or federal court were very different circumstances. And in this case, the state is going to be the defendant. So it would be a case brought by fossil fuel interests opposed to the bill suing the state. And in that case, you're not going to have fights over the venue. The state as the defendant is not going to be encouraged to delay or seek to raise procedural issues that would make the cost greater. It's likely to proceed fairly promptly. And I would say, from my perspective as a practitioner, those initial facial challenges will likely be resolved on the papers. So they're legal issues that likely won't require a trial, and therefore can be resolved fairly expeditiously in court, maybe even on summary judgment. And so certainly I'd encourage you to talk to the AG about their perspective of how that would proceed.
I think she prefer not to testify, but has indicated that she expects that the litigation would be, they would move to have litigation in federal, not state court, they being the oil company.
Yeah.
Which they're doing right now on the ExxonMobil case.
Yeah, that sounds consistent with my view of where it would be and how it would proceed.
I don't think she wishes to testify.
Understood. Well, I'm happy to speak more to
It's interesting that you brought up an interesting point, and I was going to make it a little later in the meeting, but I'll do it now. That if there are people opposed to the bill, please contact Ben or myself, and we'd like to hear from you. But the companies have chosen not to testify on the bill because they want to save their powder for court.
If this is the appropriate point, I did want to speak just briefly to the API memo, which you received, the fossil fuel industry group. I think a lot of the topics covered in that memo have been addressed by your prior witnesses. I would just note that that memo appears to be pretty much a replicate of what they filed in New York, and therefore some of the statements in there are inaccurate with respect to the bill you all have before you. For example, it alleges that there could be some concerns about disproportionate penalties. Your legislation actually specifically addresses that to make sure that any cost recovery paid by a responsible party is proportional to their share of contributions. So I want to note that.
And it's not punitive.
And it's not punitive, correct.
Senator.
Thank you for starting to talk about the API memo. I mean, another thing that I noticed is that they stated we're trying to go back 70 years. As far as I can tell, we're going back 19. But just another point. I wanted to go back around to when you were talking about the defensibility of this. And my understanding is that it would be reviewed under a rational basis standard. And I was wondering if you could talk a bit more about that, especially in the circumstance when the state is the defendant. And yeah, could you expand a bit more on that and what that all means?
Yeah, absolutely. Yeah, no, I think you're right. Most of the claims that might be filed here would be reviewed under a rational basis standard. That's a standard that's very deferential to the state. It recognizes the important role that state legislatures play and the authority they have to exercise the state's police powers to protect their citizens, and therefore requires a review at a very deferential level, simply to ensure that they are making rational choices based on reasonable evidence to support the conclusions they're reaching. To some of the points that come up here today, it doesn't require that the legislature solves all the problem at once. It can focus on specific aspects of the problem to address first, as this legislation does. And the committee here is building the kind of record that would support that kind of rational basis approach. And a number of provisions in the bill appropriately give state agencies the authority to look at and use, for example, the kind of peer-reviewed consensus evidence that you just heard from Professor Mencken in developing these cost estimates and then determining the appropriate allocations for each responsible party.
Thank you. And could you also talk a bit more about strict liability? I mean, the memo that we received from API, the header for one of the paragraphs says that there's an improper use of the strict liability standard. Can you talk on whether you agree or disagree with that and why?
Yeah, I would defer, I disagree, but I think also you've heard from other experts, including Professor Rothschild and Dean Rushlow on some of these issues. The strict liability standard is something that's used consistently in federal and in state law. CERCLA applies that same approach. And if you look at the cases that evaluated CERCLA's application, it was both retroactive, like this bill is, it applies back a period of time, but also applies strict liability to find that that is an appropriate mechanism for a state to use, or the federal government to use in that case, to determine the economic costs and benefits and burdens of particular impacts. And as Chair Sears noted, we're really looking there at an objective standard as to what objectively was known at the time, particularly when you're applying something retroactively, what was objectively known at that time. And I wanted to speak briefly to your question about just the evidence there. It is objective, so we're not necessarily saying subjectively what did these companies know, but I think the record is very complete as to what they knew going back many years. And I would refer you in particular, the Attorney General has a very extensive documentation of this in their briefing, in their current case under consumer fraud law, as to what was known when. And so the committee could certainly look at, and I think there is, that may be submitted with other testimony to the committee. So you have that information in front of you as to what was known when. But I do want to be clear, strict liability is not subjective. So important to know that, but it's an objective standard. So what should have been known at the time, not necessarily what any individual company knew.
Thank you. Continue on. Kind of interrupted your testimony.
Oh, sorry, I thought you were.
I think
Well,
those,
I did it. I started it. So
I think those were the most of the
we can
points.
both apologize.
Those were most of the points I wanted to make. On the litigation itself, the other thing I was going to say is there may be a facial challenge that will resolve whether this proposal or proposed bill is can go forward. There were some questions raised in earlier testimony, questions from the committee about would there also be challenges to the individual assessments that ANR issues to some of these responsible parties. And the answer is there is process there to allow that judicial review, contested case and judicial review. But I do want to be very clear about the difference between a facial challenge at the beginning as to whether or not the statute can go forward and those later challenges to the assessments. When we're in that assessment evaluation, and if those are appealed, there's likely already been a determination that the statutory program is appropriate and constitutional and can go forward. And so those later challenges are not about will Vermont collect money, but really about how much Vermont will collect and are the methodologies used appropriate. So when you're thinking about that question of defending the bill, I think it's important to be clear about those two different issues. And in my mind, it's really, it's not a question of can we afford to defend the bill, but can Vermonters afford not to pursue this type of program? If we don't pursue this, then we are saying to Vermonters, you will bear the cost of these impacts. And I think there's a very important policy decision to be made on that point as to what we are doing to protect Vermonters from these extreme costs.
Speaking of cost, we heard earlier that, from a witness about a $500,000 loss to a neighbor's crop. And I understand that's an anecdote that someone else is bringing in about another person, but, $500,000, with litigation like this, are you able to provide any sort of ballpark estimate of what it would cost?
I'm not in a great position to ballpark it. It really depends on the issues that are raised and how quickly they're resolved. I do think there's a path here that is less litigious than maybe has been suggested to resolve the big picture issue of whether this approach is constitutional and defensible, as I think it is.
Thank you.
Is there anything you would change in the bill that strikes you as problematic?
I don't have specific line item edits to the bill. I really was asked to look at a higher level at some of the
No, I understand, but
general
I wondered
issues.
if anything stuck out.
It looks very well designed to me, and I'm happy to convey some. If I have any, I'm happy to convey those to
That
some
would be
others who can ask.
appreciated.
Absolutely.
Actually, one last question. So if corporation wants to contest A&R's finding, my understanding is it would go to the Supreme Court. And when they are looking at whether or not something is scientific and accurate, what type of standard, or rather, how do they determine whether or not something is adequately scientific and accurate?
Yeah, that kind of appeal, the Supreme Court would typically defer to the expertise of the agency making the determination. So they will consider legal issues on a de novo basis, which would mean they consider them anew, in the same way that the state agency may have, but on expertise, on issues of modeling methodologies, they typically would defer to the expertise of the agency.
So just to follow up, if part of the contest is to say that these methods are not accurate and therefore they don't apply, if I'm the plaintiff suing the state, and would the Vermont Supreme Court still defer to A&R, or would they go through a process to determine whether or not the methods A&R used were in fact scientific and accurate?
They're going to look at whether it will be a deferential level of review. They will look at whether there's a basis for the agency's methodologies and determinations, and we'll make sure that those methodologies are not arbitrary and capricious. In other words, there's not some clear error in them that indicates they should not be relied on, but they're not going to reweigh the evidence themselves, the different methodologies, and pick one methodology. It's simply about whether the agency's approach is supported by record evidence.
Thank you.
Other questions? Hey, thank you so much.
Thank you very much.
Yep, oh, sir.
Mr. Chair, Anthony Arpino with the Conservation Law Foundation. I have some written testimony that I plan to submit subsequently that speaks to Senator Norris's question, but I see you're ahead of time. I could read out into the record some of that since I'm here today, if it'd be helpful to you. If not, I can just submit it in writing subsequently. But we do feel it is important that you establish a record because of the due process.
Why don't you take the witness stand? We've got about 15 minutes.
I can do it quicker than that. Appreciate the opportunity and appreciate the question, because it's important that it be explained rather than just asserted. Again, Anthony Arpino, on behalf of the Conservation.
You'll provide some written testimony.
I will provide this in writing as well, and within that writing, you'll find hot links to the actual primary source documents that I'm referencing, so you can go back and see. As Jeff explained, it's an objective standard, but you can see what was out there and what was known by the industry at the time. So speaking again to the historical knowledge, a lot of that resulted in part from science that was produced internally and kept secret by some of the same big fossil fuel companies who would likely be responsible parties under S-259. And as Jeff mentioned, the Vermont Attorney General's office has already collected much of that information for the state of Vermont. It is reflected in its pending consumer fraud case against several big oil companies based on their cover-up and deceptive practices, and relates to their public climate denial and greenwashing. Now, it's important to understand, and CLF certainly applauds the AG's effort to hold big oil accountable for their climate deception. They have a strong case, but it's important to stress once again that that is a different type of case. That is about punishing wrongful conduct. This is about cost recovery. And so to the extent there's important overlap in the evidence to show that it's fair to look backwards in time and to say to these fossil fuel companies, you knew and you understood at the time that you're being held accountable, that your products and your activities did have some harmful activity. That's where the evidentiary overlap is important, but it's the same evidence, it just has different significance. The AG's complaint succinctly summarizes the state of scientific knowledge possessed by or accessible to the fossil fuel industry, and I recommend that the committee ask, even if they don't want to testify, the AG's office submit that evidence relevant to S-259 that it has supported into the legislative record for the committee's review. And in case of any subsequent court review, you can demonstrate to the court that you understood the state of the knowledge that was in there. But I am going to go through a few specific examples. Recent reporting in the Guardian newspaper, for example, traces fossil fuel industry funded scientific knowledge of climate change back as far as 1954. Primary source excerpts from that industry funded research are also found at a link that will be in my written testimony. One example of that would be Royal Dutch Shell Corporation. That's been cited in investigative reporting by L. Michael Bushbaum, and he reports that in 1977, Shell co-founded and helped organize a week-long academic workshop on the carbon cycle staged by the Scientific Committee Problems on the Environment, or SCOPE, an international research collaboration between Bert Bolin and the Swedish meteorologist who would later become the first chairman of the Intergovernmental Panel on Climate Change. So the point here is they were paying the people that went on to become the leading scientific experts in this field. This was in 1977. The workshop's 491-page report, again linked in my written testimony, was just one of dozens of Shell oil-backed academic initiatives and report published throughout the 1970s that spelled out the risks posed by burning fossil fuels in increasingly vivid terms, peppered with warnings of, quote, drastic economic consequences, which is, of course, relevant to cost recovery, and severe stresses on human societies. Again, a quote from that written report. Much of the knowledge is then reflected in a chilling video produced by Royal Dutch Shell and released in 1991 called Climate of Concern. It is still available on YouTube. You can watch a Shell-produced video from 1991, again, almost a decade before the covered period in this bill, in which they document and it belies the widespread availability of scientific research linking the burning of fossil fuels to climate disruption and cost-driving impacts like flooding, like crop failure, which is discussed in their video and which you heard about today from one of your local farmers. And that's something that has been extensively documented. Even older evidence proves that Shell was not alone in the industry in its awareness of the problem. Rather, that knowledge was disseminated on an industry-wide basis by the American Petroleum Institute. That's the same trade organization that has submitted to your committee a memo opposing this legislation. If you have viewed the popular film Oppenheimer, you'll recognize the name Edward Teller that was mentioned by Rick Heady before, one of the leading physicists who worked on the hydrogen bomb. Aside from that work, he also studied climate change resulting from the burning of fossil fuels. In 1959, again, many decades before the covered period that you're retroactively assessing cost recovery for, he gave a cautionary address to the American Petroleum Institute. In his address, he gave a stark warning of the assessment of and warning about climate change, and this is a quote from it. A temperature rise corresponding to a 10% increase in carbon dioxide will be sufficient to melt the ice cap and submerge New York. All the coastal cities would be covered, and since a considerable percentage of the human race lives in coastal regions, I think that this chemical contamination, again, his words, chemical contamination, important and it's linked to the work that you've done before on Saint-Gobain, etc., is more serious than most people tend to believe. Also in my written testimony, you'll see the research of Oxford senior research fellow Benjamin Franta, who uncovered a document that contains the 1965 annual remarks of the American Petroleum Institute, again, the trade association that's opposing this bill. President Frank Eichert, his remarks to big oil executives include acknowledgement of a President Johnson administration report which warns that fossil fuel combustion could cause significant climactic changes by the end of the 20th century. In his remarks, again, this is the president of the American Petroleum Institute, he noted that, quote, one of the most important predictions of the report was that carbon dioxide is being added to the Earth's atmosphere by the burning of coal, oil, and natural gas, which would lead to marked changes in the climate beyond local or even national efforts. He then warned industry leaders, this report unquestionably will fan emotions, raise fears, and bring demands for action. So they understood that as the science evolved, the public would demand action. The substance of the report is that there is still time to save the world's peoples from the catastrophic consequences of pollution, but time is running out. That is the president of the Big Oil Trade Association speaking to the executives of Big Oil in the 1960s. These and many more primary sources detailing pre-1990 Big Oil awareness of the harmful nature of their products on the climate change may also be found in a brief to the U.S. Court of Appeals, which I have included a link to in the written testimony I will submit. And the list goes on. I also just point to a local source. There was growing awareness of global warming problem had spread even here in Vermont. In 1989, as reported by the Washington Post, then Governor Madeline Kunin addressed the United Nations on the need to take action on global warming, something Governor Kunin also carried over into her 1989 inaugural address. So the point being, as Jeff said before me, this is an objective standard. It doesn't depend on proving that each individual big oil company knew that their activities were causing the kind of harms that it would cause the kind of harms that Vermont is now experiencing. However, even if you were to apply a subjective test, the public record is replete with indications pre the covered period in S-259 that big oil executives understood the connection between their products and their activities and the kind of harms and costs Vermont is now experiencing in 2023, 2024, and will experience into the future. And from a due process standpoint, when we talk about a potential constitutional challenge against S-259, I would submit, and I believe the case law would support, this level of widespread scientific consensus and industry-specific knowledge is more than sufficient to satisfy any due process concerns that it is fair to retroactively assess cost of recovery against big oil. And I appreciate your giving me the time to just complete the record on that, because Senator Norris is entirely appropriate to say that it should be.
Look forward to seeing your written testimony. I don't know if there's any questions.
That's the smallest report you could find, was 491 pages.
There are many others for your reading pleasure, and you'll find links to them in the materials that I submitted.
We're gonna talk with legislative council now. Mike is here.
Oh, thank you. I didn't know if Senator Buckles had a question.
Oh, I'm sorry.
Yeah.
Did you have a
Well,
question?
yeah, no, I did have a question, and so
I'm
it's,
sorry.
no, it's okay. It seems that there is significant evidence of knowledge, and that based on the time frame of that, this is actually a pretty conservative time frame in this bill. Would you agree?
I would agree with that. It's certainly as you heard from John Groveman at the beginning of this testimony, when you look at the hazardous waste context where CERCLA is, you've gone back many decades, and that's been affirmed going back to the 50s. I don't think anyone is suggesting going back that far, but certainly there is a defensible case to start at some point earlier than 2000, because speaking to the concerns that the chairman raised earlier, we want to make sure that the money we recover for Vermonters makes a meaningful difference. And the way the bill is structured now, the further back you go, or the closer in time, like what Rick Heady was saying, you could go as contemporary as 2023. There's also a suggestion that you could go back at least to the mid-90s and have a defensible framework based on the scientific evidence that was out there, the knowledge that was out there, and the moves by the international community and the federal government to start taking a heavier role in regulating the activities of big oil companies. So thank you for your question.
Yeah, thank you.
Thank you.
Thank you.
Mike, if you would join us, please. I want to thank all the testimonies so far this morning. It's been extremely helpful in understanding. One thing that's come to my mind, Mike, is that whenever they're counting up, what we're counting is what infrastructure changes and what damages have been done, how do we compensate either the state or the people who've been impacted for those damages. And yet, what we've seen in other places is sometimes the full damages aren't known at the time when we go to court. I'm a little worried about that, given a recent case against St. Gobain in Bennington, where state settled with St. Gobain on certain things, and then a private lawsuit settled another area. And then, for those of you who don't know Bennington, Route 7 is kind of and Route 9 are the intersections that come in our downtown. And the Route 9 is east-west, west-east. And we set the dividing line roughly there and said anything that was beyond Route 9 was something else if it ever came up. And then just this winter, wells began testing it with high levels of PFOA in them in the south of Route 9 residential areas. So everything's already been settled. It's I would assume unable to be reopened. And it's hard to assess who's responsible. It could be somebody else, actually. So I'm wondering in this case, how that all works with the strict liability and at whatever time that the state decides to bring suit, whatever methods the treasurer uses to assess the damages. What about future damages that weren't caught?
Well, first, as you just heard from Jeff Hand and Anthony and probably others, there's likely going to be litigation immediately or very soon after there's passage, and it's going to be constitutional challenges on the face of the act itself. So you won't even have the state treasurer's cost report. That's not due until 2025. Maybe you have it, maybe you don't. You could, for the purposes of the formula, have the treasurer update that report on a regular basis to account for additional costs. But remember, the cost period is defined. We were just talking about what period to assess that in. Right now, it is defined between that 2000 and 2019 period. I do think if the law is successful when challenged and it's implemented, you will have opportunity in the future to reassess that time period and seek damages for another time period, 2019 to whenever. So I do think you have options for assessing future costs. It may require additional litigation, additional assessments, additional cost recovery demands, but there's opportunity.
Been approached by Secretary Moore. She'll be here next week to discuss it, but they're also doing their resilience implementation strategy and how to make them compatible with this bill. How to make that implementation strategy compatible with this bill.
I think that's I wouldn't say easy to do, but I think it's very viable. You have the plan in here, which is supposed to identify those infrastructure projects that are going to receive funding. Those infrastructure projects probably have some very close relations to what is being identified in the A&R plan, the climate office plan. I think you could, with Senate Secretary Moore, kind of identify what those similarities are and develop. You could use the resiliency plan if it fits your needs, if it meets those projects.
I believe the treasurer is involved in that one too. So.
And so I think you have a real possibility to use that plan as instead of A&R coming up with another plan. You could direct them as part of their resiliency plan to identify those projects that qualify underneath this bill or something similar.
How do we get the Intervale farmers and the farmer in the Winooski Valley? How do we get them? Make sure that they are covered in anything that we're doing.
Well, I think you have to look at that definition of currently under the bill, what climate change adaptive infrastructure project is and whether or not what they're alleging their damages are would fall under this or could be remedied by a project underneath that definition. From my recollection, I don't believe crop loss is listed. And that, one of the things that farmers can do is they can take out crop insurance and it does have a flood insurance component, but it can be expensive and it doesn't pay 100%. So some farmers don't get it.
Yeah, and then some insurance companies, I'm not talking about Vermont, like in Fort Myers, even when the adjusters agreed on an amount, the insurance companies lowballed the payments to the homeowners who were damaged in that.
But for example, if there was flooding where there was a loss of agricultural topsoil and the farm needed to reinvigorate its soil, that loss of ag topsoil is an infrastructure project that's listed. There are other things. There are things like drainage systems. All farms need to have stormwater drainage systems, and maybe part of what their damages are because of their, the fact that their stormwater drainage system isn't sized to the type of precipitation and the scope of precipitation that the state is currently receiving because of climate change. So there's opportunity for farmers in this language. The crop loss on its own, I don't see that here, and there's.
Well, I'd like to consider putting it in.
Okay. It would probably be crop loss when it's not otherwise compensated for.
Otherwise, yeah, that's fine. I'm thinking of Senator Starr's gravel pit. I don't know if he's told you about the gravel pit.
I hear about the gravel pit all the time.
But it washed away. It no longer had his gravel pit. Senator Bahowski and then Senator Hussein.
Yeah, I certainly appreciate the desire to get our agricultural community in. And one of the things I spoke briefly to the gentleman from the Intervale farm in the break, and one of the things he mentioned that might be helpful would be either sort of co-insurance funds or no interest loans to front the cost while FEMA gets their stuff together. So I don't know if that would be coverable under the language in the bill. But that was one thing he explicitly mentioned, and that was not my actual comment, but came up while you were talking, Senator Sears. So I don't know, Michael, if you feel like that's already an option for this super fund, or if we would need to add language.
So you said co-insurance?
Yeah, so sometimes like the FEMA has like a match And so, maybe allowing a farmer to use that towards part of the match, or allowing it to be utilized as a no-interest loan while they wait for those other funds.
So, this is me just freestyling a little bit. And it involves a couple of different things that are going on. A couple of years ago, the state elected to pay for dairy farmers premiums to participate in what's called the Dairy Margin Coverage Program, which is effectively a federal insurance program to account for the market in dairy, which is volatile. And so there's a formula, and depending on what the price of milk is versus the price of grain versus other inputs, farmers get paid out. And the state pays about $1 million a year for dairy farmers to participate, and then it usually pays out exponentially more than that. At the same time, in S213, which is just passed out of Senate Natural Resources, there's a proposal for A&R to complete mapping of all river corridor flood risks. And therefore there would be identified maps that go beyond the FEMA flood hazard maps to identify those areas in Vermont that are subject to flooding that is different from the FEMA inundation flooding.
Mm-hmm.
I could see a program where the state uses these costs, what they recover in reimbursement from these companies, to establish a program to pay for the premiums, crop insurance premiums for farmers that are located in mapped river corridors with flood risk.
Okay.
So I think there's options for that. Right now, the bill doesn't provide for something of that specificity.
Okay.
But I do think as this program goes forward and it's successful, you will have opportunity to use the funds and appropriate the funds in ways that you deem necessary or appropriate.
Thank you. And that actually brings me to sort of what my original question was. And I think we talked about this briefly the last time we brought up the bill, and that was around housing infrastructure, and whether that sort of qualifies under the infrastructure portion of this. Because one of the things I know we experienced in this most recent flooding, and we heard from our witnesses today, that people who are the most vulnerable, the most marginalized, often live in areas that'll be the most impacted. And when their housing is destroyed, particularly right now in housing crisis, they have nowhere to go. And so I'd love to see language, and perhaps it's a percentage of what is destroyed that can be rebuilt out of a floodplain, because that is what we've also heard, is towns don't have the capacity to move those buildings out of floodplains. People don't have the capacity to move into a house out of the floodplain. So I want to make sure that's captured here, that this fund is able to be used for specific types of housing.
Well, it does allow for repair, adaptation for households and preparing for future climate change disruption. That's somewhat ambiguous. And there's also authority for relocating. There's also authority for weatherization and upgrades and retrofits in public and private buildings, including public housing. And there's also the authority for nature-based solutions, which is something that is defined as that utilize or mimic a natural process that may also, I think you have the ability to say relocate, implement a nature-based solution where the housing was damaged, have new housing that is flood resilient. I think there's opportunity here for that. You may want to be more specific.
That was my concern too, is that the way the language is now, it might not very explicitly say building new housing is okay if it's out of a floodplain and it's affordable.
To relocate flood-prone communities out of the risk, yeah, I could see that.
Awesome. That was my piece. So thank you.
I was taking the pictures from last night of some homes in California that are obviously going to be sliding down the hill fairly shortly.
There's homes like that in Barrie that we saw when we visited.
Yeah.
No, I hear you.
I wasn't on that tour,
We should have come with us.
I didn't know it was happening. Senator Norris wasn't there.
I miss all the fun times.
Anyway, Senator,
Thanks. I wanted to look at the rulemaking and also a piece on page 8 under the liability section. So I guess first for page 8, line 7, saying that the agency shall use the EPA's emission factors for greenhouse gas inventories for the purposes of determining the amount. And then on page 12, for the rulemaking, the first rule is adopting methodologies using the best available science to identify responsible parties and so on. And so is ANR allowed to use other scientific methods if they think that those methods are more accurate, or must they use the EPA's method that's listed on page 8?
I can see how you could read those to conflict, but I also think it would be very easy to eliminate that conflict by saying on page 8, they use the EPA inventories or other methodologies adopted via rule under 599A, something along those
why
lines.
don't we do that in a redraft?
Thank you. And the reason I ask is because, well, I know ANR is coming in next week, but from what I can recall, and someone correct me if I'm wrong, I think they were seeking a bit more flexibility in determining what methods they can use to make these calculations. And if I'm wrong, I'm sure I'll be corrected next week, but I just want to try getting at that. So
I think
if that,
they want the resilience implementation strategy to be compatible with this bill. So they don't have to do two. But I think how it gets done would be as flexible as possible.
I did review the secretary's testimony, and one of the things she pointed out was the use of the resiliency plan. The other thing she pointed out was there's unclear enforcement, which is very easy to fix. And then the third thing she pointed out is she said she wanted it to work more like Superfund, more like CERCLA or the state CERCLA. And that's where I wasn't quite sure what that's where I saw her focusing on the process and how the process works. And that's where I'm kind of intrigued by what I believe she specifically offered to bring in someone that's skilled from the agency and Superfund to talk about how they do it and how it could work here. And that is something that I'm very curious as to what her testimony will be.
yeah, and also just add, I would like to make sure that they have access to, whatever tools or methods are the most scientific and are the most accurate, so we can get something that is proportional and rational. And yeah, so those are my thoughts on that.
Oh, clearly.
I had a question for you, Senator Sears. I want to make sure that the aspects of the bill really are as strong towards climate justice and mitigating the damage to the people who've been harmed the most. And I'm wondering if we had a chance to reach out to the Environmental Justice Advisory Council to see if they have thoughts on how to do that. And if not, I'm happy to reach out to them if that's, I think that it would just be helpful to hear. I'm sure they're not opposed to the bill. They might just have additions.
Yeah, I have no problem testifying at some point, perhaps next week or the week after. I mean, we got 2 weeks left, so.
Exactly.
But
Okay.
briefer the better.
Okay.
Just if there's issues that they think. If you want to reach out to them, that's fine, or work with Ben to reach out to them at a time.
Perfect. Will do. How about that?
Are there other things from Mike that people see as possible changes? Is there another committee working on the resilience implementation strategy? Of the legislation?
I would say maybe. The 213 bill that came out of Senate Natural definitely has some things in it that are likely covered in the resiliency plan, but it's not a comprehensive one-to-one. But I know GovOps is working on kind of the municipal response to flood and slash disaster response. But again, not one-to-one to what A&R would be proposing.
So I would just, if you wanted to put together how the two would work together, some thoughts on that.
What
The resilience implementation strategy could work together with this bill.
oh, sure, yeah, that's fine.
The idea that you floated about, having only one rather than two different assessments, it doesn't make sense to recreate the wheel twice.
And the secretary said she is bringing in the head of the climate, was it the head of the climate officer, the person that drafted the resilience
Who's
plan?
So,
I think
yes,
it's the person who drafted this.
Secretary Moore is bringing in Marion Walls, who,
And the treasurer's coming.
she is, serves as the Resilience and Adaptation Coordinator, at A&R's Climate Action Office.
Okay. I think you'll hear from them specifically how it can plug in, but I can also.
Yeah, anything you
that
can
on
do, given the time crunch, anything we can
Yeah,
do
understood.
help you out in drafting is all the better.
I probably will start the worksheet of a strike all amendment to start addressing things like Senator Wyoski's concern and the other concerns, and just work through putting in an enforcement provision, things like that. It won't be anything really major, but it'll just start fixing some of the little issues that people have identified.
Oh, gosh. Oh, I'm involved. 4 years radical idea.
I don't know, I've heard you've done some pretty groundbreaking work in your day.
Yeah, but I wouldn't have done this 10 years ago, I can tell you that.
Growth and evolution is good.